Texas's story special. Back in the 1990s, before the Grutter case, constitutional experts thought the days of race preferential admissions policies were numbered. Some lawsuits had already been filed, including the one against the University of Texas. The Supreme Court had never really approved this kind of discrimination. The only case that had been the famously fractured 1978 case of UC Regents versus Bakke, in which 4 justices had essentially said, sure, go ahead, do whatever you want. 4 justices had said, this is clearly illegal, and one single justice, Lewis Powell, had straddled the fence. According to Powell, the purpose for such discrimination could not be to increase the number of minority graduates. That was not permitted by the Constitution, he thought. It could not be to compensate minority students for past societal discrimination. It had to be to make education better for all students by exposing them to diversity. Curiously, he used Harvard University as his example, because he'd gone there as a graduate student, of what was permissible. They had a program under which they tried to get a diversity, people from different states. He didn't even realize that had been brought up simply to minimize the number of Jewish students that went to Harvard. Didn't know. He didn't know the history of it. In the years after Bakke, the Supreme Court had issued several opinions requiring race neutrality in other contexts. So the Fifth Circuit thought, well, they'll probably not follow Powell's opinion in Bakke, and ordered the UT to stop discriminating. The Texas legislature then stepped in and responded with a statutory plan that required Texas to admit students who graduated in the top 10% of their high school class in Texas. That results in a pretty racially diverse group. So UT at least publicly claimed during this period that the top 10% plan gave them an equally diverse student body. In 1996, 18.6% of UT's freshman class had been either African American or Hispanic. By 2004, mostly through the use of the top 10 method, the freshman class was 21.4% African American or Hispanic, so it had actually gone up. Yet as soon as the Grutter case was decided, UT announced plans to add racial preferences on top of the 10% plan, because they couldn't get rid of the 10% plan. It was statutory. So that got them up to 25.5% African American or Hispanic. And this is getting pretty far from Bakke and Grutter's notion of critical mass. 25.5% is looking pretty high, looking a lot more like an effort to move towards having UT's class reflect the demographics of Texas. And that's why Texas was such a tempting target. They really were in a position where arguments could be made against them that couldn't be made in other cases. If the Supreme Court had simply ruled in Fisher, we are not sure what we meant by critical mass in the Grutter case, but we're pretty sure that 25.5% is well beyond that. You know, they could have decided the case that way. That would have been a straight win for Ms. Fisher, but it really wouldn't have had that much in the way of precedential value. Few states have high enough minority population for such a ceiling to matter to them. So for whatever reason, the court didn't go that route. Acknowledging that Grutter had been deferential to colleges and universities, instead, the court in Fisher clarified that colleges and universities still have to provide, quote, a reasoned and principled explanation for its diversity goal, and tough-minded strict scrutiny will apply without any deference to the question of narrow tailoring. Now, recall that the traditional strict scrutiny test has 2 parts to it. First, race discriminators must demonstrate compelling purpose. Not a really good purpose, but a compelling purpose. On this half of the formula, the Fisher court said the governmental body, what they did is they essentially brushed over the deference point. So they didn't change the law there. On the second half of the test, they state that the discriminating governmental body must show its actual policy is narrowly tailored to achieve that compelling purpose. And here they clarified that they were going to be tough. They were going to use strict scrutiny. I am not convinced that this bifurcated approach, deference on half the test, no deference on the other half of the test, is going to work in practice. It's unstable. It will depend on how the implementing court decides to conceptualize the compelling purpose. You can view it broadly, view it narrowly, and it's really, the two parts of the test are a seamless web. You can't just have one rule applying to one and to the other, but it's the law until further notice. That's the best we can do. What will it mean to say the court will strictly scrutinize whether an admissions policy is narrowly tailored to serve the interest of capturing educational advantages of diversity? It's hard to say. Not much I can say here. But I do believe that, among other things, universities are going to be expected to tailor their programs to take account of the educational disadvantages of racial preferences, not just the advantages. Among those disadvantages is that mounting evidence that preferential treatment hurts the chances of preference beneficiaries to succeed, most notably in the area of science and engineering. I don't think that's a stretch for the court. In Bakke, Powell insisted that a college or university that claims to be interested in diversity has to show a concern for other kinds of diversity, too. It can't just be racial diversity. They have to convince the court that they're really sincere about this notion of diversity helps education. Bakke ended up winning his case as a result. Similarly, the University of Texas claims to be concerned about conferring the benefits of diversity upon students. Well, if they're concerned about the educational benefits of diversity, they need to be concerned about the educational disadvantages of diversity as well. And they have to have a program that at least tries to reconcile the various research now, particularly in the area of science and engineering. If the Fifth Circuit actually does that, if it takes the Fisher standard and actually requires the University of Texas to show that it is taking into consideration the research on mismatch, then this case really will be a blockbuster. But don't get too excited yet.